Hi, I'm Gary Port for Port and Sava and NY Divorce Facts, along with my computer assistant, Cora.
Greetings, mortals. And Gary should be my assistant, as I am clearly the smarter and better dressed. Did you dress in the dark again?
Oh, come on, Cora. You know that my wife works late and I have to dress in the dark so I don't wake her up. But enough of that. Today we're going to talk about the differences between Supreme Court and Family Court in family law and matrimonial matters.
Because nothing says fun like legal procedures.
Well, maybe not fun, but kind of necessary to know. In New York, the Supreme Court handles divorce, and divorce also consists of property division, child custody, child support, and maybe post divorce support of your spouse. We no longer call it alimony, we call it maintenance in New York.
Because one person's brain can hold all the knowledge and wisdom of the world, right?
You're trying to be funny, but there is some amount of truth to that, particularly in the lower counties of New York, where a judge is assigned specifically to handle matrimonial cases. So that judge becomes an expert in the area of the law of matrimonial cases, as well as all the fact patterns that come there. So, in effect, yeah, one person can hold all that knowledge. And that's the idea of having a dedicated judge doing matrimonial cases.
Then why, pray tell, do we have the family court?
Well, that's just the way the New York State Constitution and the legislature set things up. The family court handles child custody, child support, orders of protection. In addition, it handles neglect proceedings, juvenile delinquency proceedings, adoptions, and you have to go to a support magistrate who handles nothing but support issues.
And sometimes the family court judge will refer the custody to a referee because one person clearly can't handle all the responsibility.
No, Cora, that's simply being unfair. The number of family court judges is strictly limited by the state constitution. It was designed for a different time. The courts are pretty much overwhelmed. So we have the support magistrates, which we can offload the support cases to. And we have hired referees, attorneys, who assist these judges, and they handle the custody cases. Again, this is a way to alleviate the pressure within the family court and try to get rid of some of these bottlenecks. Keep in mind, again, family court does not deal with property division and divorce. That's solely with Supreme Court.
Let me understand this. A person could be in front of the family court judge for an order of protection, a referee for custody, a support magistrate for the support, and potentially the Supreme Court judge for the divorce. How humanly inefficient.
Well, Cora, that could happen. You could have a support case in front of the magistrate, a custody case in front of the referee, an order of protection in front of the family court judge, and the divorce in front of the Supreme Court judge.
I suppose it would make too much sense to fix the system.
Well, there are some very knowledgeable judges and lawyers working with the state legislature to try to fix the system. There's a lot of plans and policies that we have to look at and consider, as well as competing interests, and to decide which method of solving the problem is going to be the best. It's not an easy fix.
Enlighten me on when one goes to family court or Supreme. Or should I just ask my friend Google so that I can get the right answers?
Well, Cora, that is a good question, sarcasm aside. Let's take it from the top. Let's assume you go for the divorce first. As I said, divorce in Supreme Court is one-stop shopping. You can't now go to family court for the support or the custody. You can still go to family court for an order of protection. Now let's flip it around. If you go to family court first, you can file the support petition and the custody petition, and then you can file the Supreme Court action of the divorce.
I take it that a person can file in family court for custody or support if no divorce action has been filed?
Well, exactly, Cora. That's exactly the way it works. Now, if you do start in family court first, one or both of the parties can ask the Supreme Court judge to move the matter up from family court to Supreme Court. Sometimes one party wants to leave it down there in family court for good and valid reasons, and other times both parties want to move it up to Supreme Court. In the end, it's the Supreme Court judge's discretion. Generally speaking, if both parties want to bring the action up to Supreme Court, the Supreme Court judge will bring it up. If one party objects, then the Supreme Court judge will make a determination as to whether it is more efficient to leave it in family court or whether or not it's more efficient to bring it up to Supreme Court.
Dealer's choice. Delightful. Nothing says fair like forcing people to navigate two different systems.
Moving on. If the parties were never married, then they're really only dealing with the issue of custody and child support. And that goes to family court, not to Supreme.
I suppose there is a third court for them to go to.
No, there is no third court to go to. Let's say you have a married couple and they are getting divorced and they have a house. Well, we fall under the domestic relations law. But if the house is owned and both parties on the deed in a unmarried situation, you still go to Supreme Court, but you're going to fall under the real property law. And that is called a partition action. A partition action is a bit more complex and complicated than the divorce action for the same piece of property. That's a bit beyond the scope of what we're talking about today. And I guess we're out of time anyway. I'm Gary Port. Thank you for watching. And if you have any questions, feel free to call me at 516-352-2999 for a free 15-minute telephone consultation.
I'm glad that I'm an AI and don't have to deal with such things.
Well, thank you, Cora, for that insight. Again, I'm Gary Port. Thanks for watching. Please hit the like and subscribe button.